Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Deborah K. Sundquist presiding.
You may be seated. Good morning, Council. Today we are here on the Carlos Alberto Machado-Rivera matter. It is work comp file number WC 236538. I'm here today joined by Judge Carlson and Judge Quinn.
Morning.
You both have been here before many times. You know the rules. 15 minutes for oral argument. You can reserve a rebuttal time, but that is your responsibility. So with that, if you're ready, Ms. Tuft.
Good morning. May it please the court. Good morning. My name is Christine Tuft and I represent the employer and insurer in this matter, and that's Installed Building Products and Helmsman. My clients have raised essentially three issues on appeal: the nature and extent of the injury, and specifically, did the injury event aggravate or accelerate the clearly documented pre-existing dental condition? Secondly, whether the awarded treatment plan is reasonable, necessary, and causally related to the injury. And third, whether the compensation judge committed legal error in awarding vocational rehabilitation benefits where no restrictions are imposed on work activities and the claimant is working without a wage loss. I know the court doesn't want to hear a long recitation of the facts in this matter, but just quickly, we have a date of injury of September 1st of 2020. It's an accepted injury in terms of the orthopedic injuries in this matter. The nature and extent issue goes to the dental issue claims. There are three important elements of the facts that I would just like to point the court to before I get into my arguments or any questions you have, and that is the pre-existing dental condition. In this matter is very important. About 6 months prior to the injury, the claimant was seen for dental treatment, had various diagnoses and various recommendations, which we think are really important to the determination of this matter. Secondly, the emergency room or urgent care record at the time of the injury, we believe is also very important, and specifically important for what it does not demonstrate. And that is, it does not demonstrate a fracture of the jaw, and it does not demonstrate anything other than one loose tooth in this matter. It doesn't show bruising or damage to the face, to the jaw, complaints of jaw pain, or complaints of anything other than the loosening of one tooth. So we think that that is important. And actually, I'll correct myself. I think it also demonstrates that there was a bridge that was damaged or broken. In the third issue or fact that we want to point the court's attention to is the treating doctor, Dr. Leon, the treating dentist, I should say, his lack of documentation in this matter, and the lack of objective documentation in his records, which he tries to pass off as mistakes in this case. So what those prior records show that I referenced are, that is of March of 2020, 6 months prior to the injury, there were at least 13 missing teeth in the claimant's mouth. He had a loose bridge. He had multiple cavities. He had what was described as relatively severe periodontal disease, and he had significant bone loss. There were multiple treatment recommendations made at that time, options offered at that time. He didn't follow through with any of those at that point in time. And then when we get to the post-injury dental records, so we have the ER records, don't show any jaw fracture, one loose tooth. We get to about 10 days later, he goes back into Dr. Leon, the treating doctor.
Ms. Tuft,
Yep.
Hi, good morning.
Good morning.
We're familiar with the facts, so
Yep.
if you don't mind, we're going to just kind of hop
Yep.
into some questions.
Absolutely.
And Mr. Peterson, you might get some of these same questions as well. You had stated that the record showed that he was missing 13 teeth before the injury. I actually counted 15 teeth.
I did as well,
Right, well,
Judge.
it
The
depends.
doctors keep referencing 13, so I
Right.
figured
So-
they knew more than me.
Right. So a lot of teeth were missing before the injury. Is it your understanding that the treatment that has been given so far has been to all of the teeth, including missing teeth?
So far since the injury? Is that what
Correct.
you're asking? It is my understanding of the treatment that has occurred since the injury is removal of the remaining teeth.
Okay, and then
And-
posts have been put in to all, I'll call them sockets, to all of the place. So even where there was missing teeth, there has been treatment.
Yeah, I'm not sure where the posts have been placed. I don't know if it's all of the sockets. And then there was bone grafting done
Okay.
as
So,
well.
and my question is do you think there's ever a circumstance where an employer and insurer should be responsible for treatment for teeth that did not exist at the time of the injury?
Right. And excellent question, Your Honor. And actually, yes, exactly our position is that the employer and insurer should not be responsible for a condition that existed prior to the injury in this matter. And in fact, that's part and parcel of the entire argument here is that really his entire condition existed and the records don't document that any additional teeth were lost as part of the injury. The additional teeth were removed as part of the treatment, but the records don't establish that any additional teeth were lost as part of the injury. So that's exactly our argument, that this is a pre-existing condition. There's not objective evidence of any change in the condition and that the employer and insurer shouldn't be responsible for treatment for the pre-existing condition.
Ms. Tuft, I have a question regarding the facts. How many teeth does a human body have? I mean, how many teeth do we have? I'm just trying to get an idea of what the 15 missing teeth represents, like what percentage of the mouth?
You would think as a dentist daughter, I might know the answer. to that. I do not know,
Okay.
Your Honor. I'm sorry.
This is what's bothering me, counsel, about this case. Dr. Leon gave an opening statement where he said the insurer pre-approved the plan. And then, and I know you didn't try the case on behalf of your client, but your fellow attorney said, well, wait a minute, I'm not prepared for that. And there was a second day of hearing. And then Dr. Leon testified, and I'm summarizing it, but testified what was actually a representative of the employer, Pamela, who had pre-approved it. And it was established that there was no record of that. It's only his testimony. The claims adjuster testified, I was not the claims adjuster then, but there's no record that we had pre-approved it, and I certainly didn't. And then the employer representative said that wasn't my job, but when asked, said it wouldn't surprise, when asked, would it surprise you if Pamela pre-approved it? No, that wouldn't surprise me. So the judge listed one of the issues. Was this pre-approved? And then there's no fact finding and there's nothing in her memorandum. And that bothers me. I mean, should this be remanded in your opinion on
Well,
that issue?
No, Your Honor, I don't think it should be because that issue wasn't appealed by anyone. So, you know, that we can, I guess, infer that the judge found that it wasn't pre-approved because she did not make a finding as to that, but it was not appealed that she failed to make a finding as to any pre-approval. So then I don't think that requires remand because that would be, you know, the court's own determination on that.
Isn't it true, Ms. Tuft, that as a judge, the judge is required by law, by statute, to make findings of fact on all the issues that were presented at hearing?
But I do agree, Your Honor, that is what the statute says. However, again, it's not up on appeal. So we could have any number of cases where we have judges that don't necessarily make decisions on every fact in this matter, and they don't get, to this court on that issue. And in this case, it didn't get to this court on that issue. There are a lot of unappealed findings in this case.
Ms. Tuft, you had indicated that one of your issues today was the reasonableness and necessity of the treatment. But again, getting to the statement of issues, I don't see that issue being listed by the judge as an issue, the reasonableness and necessity of the treatment. The nature and extent is, but not the actual reasonableness of the treatment.
Just give me one. I do see what you're saying, Judge Carlson. I mean, I think, arguably that goes to what Judge Quinn was saying about issue number 9, because it does say, if so, what extent of treatment, but it says was approved. And so that goes to the approval question or issue that was raised by Judge Quinn. But I do think it's clear that the judge addressed that issue. And I don't know that portion of the transcript off the top of my head. I apologize. I did read it, but I didn't read it very specific to that question. But I don't know whether in discussion on the record, the parties further agreed that that was a specific issue.
Yeah.
And
Well,
I'm a little
go ahead.
confused, Ms. Tupp, because under statement of the issues, number 4, it does discuss the interveners, and then it goes on to say, including an evaluation of whether the treatment provided was reasonable, necessary, and causally related to the
Thank you,
work
Judge Sundquist. Yes.
But as to reasonableness and necessity, even Dr. Rodas says, well, this treatment it's not the way I would go. There's a less expensive way, but it's a way to go, and it's reasonable. I mean, causation seems to be the real issue here.
Yes, I mean, I don't agree necessarily that it's the reasonable treatment for the factual situation we have involved here. I agree that Judge Rodas said that it could be an option to be considered, but he didn't find that it was the reasonable option given the facts in this case. But causation is also a key factor in this matter as well. And I think, one of those points on that is the fact that, I understand the Nord decision. I understand the deference, but the Nord decision does not say that the deference is absolute. The Nord decision says that deference to a choice between conflicting expert opinions is not warranted where the facts upon which the opinions are based is inaccurate. And that's important in this case because of the facts that demonstrate and are really undisputed that the scans, the x-rays, the diagnostics, pre and post injury showed the same thing. And there is a lack of documentation to support the opinions of Dr. Leon in this matter. It is clear from the records that he didn't document things such as the loosening, the extent of the loosening of the teeth, which is important. And so then the question becomes, does the opinion of the doctor get to benefit from his lack of documentation? And then he can just say whatever he wants when he writes an opinion. It's our position that lack of documentation, the lack of objective information there, then therefore does not require the deference of this court regarding causation in this matter. And I would like to reserve my remaining time, if I may,
Yes.
for rebuttal.
I appreciate that, but I'm going to take it anyway. I just have one quick question for you on your last issue. The statute says what it says, the rule says what it says. There are no restrictions. There is no wage loss. There's no medical management. That's what the rule says. Given the communication issues that have existed in this case, don't you kind of want it anyway? If your client is going to be responsible. So let's assume that for that.
And that's the issue I was going to reserve my rebuttal
Yeah,
time
okay.
for, so that's fine. No, Your Honor, I don't think that my clients just simply want medical management in this matter. I think 176.102 is very clear on the basis, I think the definition of medical management, you know, and the reason for it is very clear as well. So, you know, in the context of, you know, the court may affirm those other elements, we still take the position that vocational rehabilitation assistance is not appropriate under the statute in this matter. And you know, again, I think the statute is clear on that issue.
Would you agree that could change in the future if there are restrictions issued or a wage loss, time off of work, et cetera?
Sure. I mean, in any case, hypothetically, things could change in the future, right?
Right. So your argument is right now, he's
Right
not
now.
entitled to a QRC or vocational rehab.
Yes, correct, Your Honor.
Thank you, Ms. Tuft. Are
Okay,
there any
I'll
other
reserve my
questions?
last 40 seconds. Thank
Thank
you.
you.
Thank you. Mr. Peterson?
Thank you, Your Honors. May it please the court, Vincent Peterson appearing on behalf of the employee. And I know you've read my brief and you know all the facts, so I'll just kind of jump into a few things, few key points. But one of the factual issues that's been raised by counsel addresses the ER visit client had. There seemed to have been some testimony about how there wasn't documentation in an ER note about how loose teeth were when someone showed up at the ER. I mean, I have a problem with that. I've been to the ER before. They're not dentists. They're certainly not going to be doing measurements as to whether teeth are mildly loose or severely loose, which frankly is the key to this whole case. My client saw Dr. Leone in the year, just the year before the injury. I think it was about 9 months prior, 6 months prior, actually. His teeth at that time, according to Dr. Leone, who testified live, were mildly loose, according to the measurements that he did. After the fall, his teeth were severely loose, in his opinion.
But here's the problem, Mr. Peterson. We don't have documentation of which of the remaining teeth, because they're not even all there, which of the remaining teeth were mildly loose before and which were severely loose after. It's all just sort of the teeth.
Right.
And that's a real problem because, well, you go ahead.
And here's why you don't need that.
So Mr. Peterson, yeah, to be even more specific, the notes from September 11th talk about 4 teeth. I think it was 231, 1 and 2, 28, 31. This was either mobility 3, which I understand to be severe mobility, and or avulsed. So there's really documentation of 4 teeth being affected on September 11th. And of those 4 teeth, one of them was also reported as missing before, but we'll call it 4 teeth. So the same question I asked Ms. Tuft, given that by documentation, 4 teeth were affected, again, where is the evidence in the record that translates to treatment for the entire mouth?
I asked him the specific question at trial. I asked him, basically, your mouth functions as one unit. You can't get partial dentures. You have to affix implants all together as one piece, or it won't function properly. Similarly, you can't get a partial fusion to your back. If you have a damaged disc above and below, they have to attach it to something. That's how the mouth functions. So it doesn't matter. And the issues as to whether the teeth were severely loose or mildly loose, their own doctor said in his deposition that he thought the fall would have caused that. He specifically said that, and I referenced that in my brief. He also said that he would be surprised if it didn't, the words that he used in his report were exacerbation. He said it exacerbated his condition. That's the standard. And if you can only
Is it the standard? There's aggravation and there's acceleration. And maybe exacerbation means the same as aggravation. I would agree with that potentially. But, and then he doesn't say temporarily exacerbated. He doesn't say permanently exacerbated. He just says exacerbated.
But I asked him these questions in the deposition. And he specifically answered them. I said, did it make it worse? He said, yes.
And was he specific to a tooth, a series of teeth, or all the teeth?
Well, I mean, that's a factual issue, but if it all functions as one unit and you need one unit of all teeth, I don't believe that that matters. He also said that he said, this is a quote from him, I would say, yeah, chances are he probably loosened and damaged some teeth. I would be really surprised if he didn't, given the nature of the accident. So I am agreeing with that. He acknowledged that the change was severe. So, I mean,
But is
if
he
you can
referring
go
to
from,
specific teeth or?
well, and I asked him that question as well. I asked Dr. Leon this question in the hearing. I said, how does it affect you to go, how does it affect the functionality of your mouth to go from mildly loose to severely loose? He said, well, mildly loose you can deal with. You can still eat. You can, not have pain. Once it goes from mildly to severe, you're done. You have to do something. You can't eat. You can't function. So, I mean, this is fundamental to our practice, this concept. So I believe that, the facts, and I think the facts there are some disputed facts, but again, this is on appeal. So I think the appellate standard here requires you to, give deference to the judge here. But
Getting back to the question that Judge Quinn asked of Ms. Tuft, do you agree that the issue of whether the dental treatment was pre-approved was not answered by the judge? And if so, is that still an issue? Do you feel like, or do you agree that it was not pre-approved?
yeah, so I was there, so I don't believe it should be remanded, even though it could potentially benefit me. And the reason I don't is because we had an off-the-record conversation about it, and I wasn't going to bring that any longer because it was clear to me that the pre-approval didn't come from the insurance adjuster and came from the employer, and that doesn't, in my reading of the rule is that wouldn't apply.
So you're not claiming that it was pre-approved?
Right.
Okay.
Exactly.
Thank you.
The other issue as to whether or not, the type of treatment that was provided, the only two types essentially that he could have were full mouth dentures or full mouth implants. That's it. You don't do like half implants. They won't do it. So it's not functioning. And so those were the two that were provided. All of the doctors, including the doctors that they had more than one doctor, said that this is a viable treatment. There was some discussion that it might not be viable because he had poor dentition and poor habits, but then it was brought out by myself, well, wait a minute. If you're doing full mouth implants, don't most of those clients have poor dentition before you do them? Or is it just provided for people that are in massive facial trauma? So that didn't make a lot of sense to me either, and I don't think it made any sense to the judge. But the bottom line was, this is a viable treatment. It's expensive. I probably should have been a dentist, but it's expensive. But it is what it is. So it's a viable option. It's a very good option. It's frankly the best option for my client. As far as the rehab issue, the rehab thing, frankly, this gentleman was working at the time. He's not now. He has a 6th grade education from, I believe it was El Salvador. He speaks Spanish. He has the posts now. He has no teeth. I think an argument could certainly be made. She's looking prospectively here. Look, this person, A, he needs somebody to help him manage this, and B, there's a decent chance he's going to have restrictions once he gets his full mouth dentures, and C, the procedures have to be conducted during the work week, so he's going to have wage loss. And none of that matters anymore because he's not working there.
Is it because it's seasonal that he's not working, or he no longer is employed?
He's no longer employed with this company.
And is it because of restrictions related to his mouth?
I wouldn't say that.
Okay.
No.
Ms. Tuft raises a good point, though. I mean, the statute says what it says, the rule says what it says. We don't have current restrictions. We don't have current wage loss, at least related to the work injury. I mean, I think it's a practical thing to do, to have medical management for this kind of procedure, for this kind of employee with the language barrier and the education barrier. But it says what it says. I mean.
I would agree.
Okay. That's really all we can say then.
And I don't have anything else. I would reserve the remaining time for Rob.
Thank you.
Mr. Peterson.
Ms. Tuft, you have about 37 seconds.
See how fast I can talk. Thank you. I appreciate that court has a great grasp on the salient points in this matter. I just want to respond on with respect to Dr. Rodas specifically and saying that he wouldn't be surprised about the damage. If you read his transcript as a whole, he says, I wouldn't be surprised, but there was no evidence of it. So yes, the type of injury event described, wouldn't be surprised if somebody had that kind of damage, but there was no evidence of it. There's the possibility that they had become worse on their own during that 6-month hiatus, and the ER records only mentioning one loose tooth are important to his overall opinions. And thank you.
Thank you.
Thank you, Ms. Tuft. Thank you, counsel. You did a great job, both of you. I appreciate it. This matter is now adjourned. We will issue the decision within 90 days. Thank you.
Thank you.
Yes. Yes.
Lindquist, the respondent.